other formal application in respect of that matter, because we think that in terms of what one of your lordships has described as judicial economy, we think that if we bring this matter up before you in the context of this motion, your lordships may wish to advert their minds to it and give directions appropriately, and that can still be done on Monday after your lordships have had a chance. But your lordship gave the preliminary indication that even though Order 36 Rule 4.3 is very clear about the order of addresses when they have elected not to adduce evidence, very clear about that, even despite that, your lordships have taken a different course, and you have indicated that that different course is on account of the way that you handle election petitions and so on. So sometimes we go by CI 47, sometimes we don't go by CI 47, and it becomes extremely difficult for anybody in these circumstances to know, in advance what the court is going to do. So my suggestion, if I may, and your lordships can determine the matter within your discretion. My understanding, not my suggestion, my understanding of what your lordship indicated was that we come back on Monday, and as at that time, depending on whether we are proceeding with the motion for stay first or not, we may be in a position to seek leave for the current motion which relates to be struck out as moot, and then we proceed in accordance with that. But I thought that I was duty bound to bring your lordship's attention to a matter which we can raise in another way, if your lordships want us to raise it, regarding the non-compliance with Order 36 Rule 4.3.
I see that, but it has even been overtaken by events. They have even filed DS first. Well, yes, so please, I think we don't have to maybe go at length to address this, because they have filed it.
Well, they have filed. Well, we haven't been served anyway, but in any case, we don't need to be served, because the point I'm making is that they brought up Order 36 Rule 4.3.
Another matter.
Well, they brought it up.
Yes, in respect of another application.
Well, how can my lord say it's in respect of another?
No,
they brought the order. My lords, they brought up the order to your court, seeking to have it applied in these proceedings.
In respect of closing addresses.
In the course of the proceeding,
but not in respect of closing addresses.
My lords, with the greatest respect, in respect of everything, because Order 36 Rule 4.3, which they brought up, is supposed to guide the conduct of the proceedings after they elect not to adduce evidence. That's what that order provides. After they elect not to do evidence, so and so and so is supposed to happen, including the addressing. So, my lords, when they raised that matter up, that's when we did start raising the issues of what that order really is about. And in the meantime, your lordships had given certain directions about the filing, which were inconsistent with Order 36 Rule 4.3, and I was respectfully drawing your lordship's attention to that. And if we come on Monday and it is appropriate, we can withdraw that and pursue the other motion for stay and the application for leave. But my lords, if you want me also to move the motion, I'm prepared to move it and draw your attention formally on record to what I've drawn to your lordship's attention.
My lords, I was trying to point out to the court that this particular motion on notice for stay of proceedings is filed pending the application for review that has yet been determined. So, my lords, it's either my learned friend withdraws the motion or is struck out because it's moot.
My lords, I completely associate myself with counsel for first respondent, and to say that I do not know what this current application is saying. It cannot be staying the application for review, which has been settled. So it has no purpose and ought to be struck out if it's not ready to to withdraw it as struck out.
My lords, I've given my indication. I'm abiding by your earlier statement about Monday, and if your lordships wish to decide otherwise, I leave it to your lordships.
So you see, it's your application which is on record. We do not want to take any step till Monday. So if I understood them, they are telling us that the motion is moot. Yes, and striking it off the record doesn't occasion any injury to anybody. So that is their submission. So that we come on Monday, take the application for stay, and then the review which has been filed.
My lord, I specifically took the opportunity to draw your lordship's attention to what I believe is still relevant in the motion. That is that we did not file. We filed this motion ahead of the deadline that your lordships has set for the filing of written addresses, because, my lords, we wanted the matter of that deadline for written addresses to be dealt with in the context of that motion. That's why that motion has still relevance. And I respectfully drew your lordship's attention to the fact that as we speak, your orders, indeed, which are pending, say that there should be simultaneous, in spite of Order 36, Rule 4.3. And I drew your lordship's attention to that because I think that it is important that we all, try to assist to arrive at the appropriate and just processes that will lead to legitimate conclusions by this court. And so, as far as I'm concerned, your indication about Monday is what I thought was appropriate, because if on Monday you hear the other application, and depending on how you address the issue of addresses being filed, because we have not filed an address. That address has not been filed because of the pendency of the stay application. And we did not wish to take a step that will be prejudicial to our own interest. Because in terms of the addresses, if our review application were granted, we assume that there are no predetermined outcomes. And therefore, if there is no predetermined outcome of a review application, the review application, if it went into in our favor, would lead to a witness being, having to testify. That would be the result of the review application. So, if we withhold filing a review, a written address, it's not out of disrespect to the court's order, but out of a respect to the fact that there's a pending review which can affect the filing of the address. Because if your lordships were to grant the review, that would mean that a witness would have to come and testify, if your lordships were to grant that. And as I said, we assume that there are no predetermined outcomes.
My lords, I have two submissions to make to the court. The first is that the application for stay, as we said, was based on the review application which has been determined. And my lords, we all know that you can't put something on nothing. So once the review application is determined, no matter the degree of legal eloquence, that application is dead. That's my first point. My second point is that the order 36 rule 4, which he refers to, has a very important qualification. It says 641, unless the judge before whom an action is tried gives direction as to the party to begin and the order of speeches. My lords, this court has given directions as to the order of speeches. So counsel cannot seek to rely on that clause, which gives the court the power to give directions otherwise than as stated in the rules. So this argument is totally misconceived once again, and should not be given any consideration by this honorable court. The application, therefore, if counsel is not willing to withdraw it, should be struck out by this court. And consequently, the court has to decide what it intends to do with this defiance of its orders by the petitioner.
Mr. Akoto, you are telling us what to do?
No, I'm not telling you. My lords, far from that. I'm not one of those lawyers who think that they know better than the court.
Order, please.
By court. This court is the opinion that the application for stay of proceedings was filed to stay proceedings before the hearing of the motion for review application. We think that as the motion for review has been determined by the full bench, the application for stay of proceedings is moot and same is struck out. The petition is adjourned to Monday, the 22nd of February 2021 at 9:30 a.m. for the pending applications to be taken.
We are grateful to the court.
My lords, we are most grateful.
All rise.